make the motion? I'll make the motion. I move the following. Whereas both developers have suggested that with modern flicker mapping coupled with the seasonality of flicker events, flicker is a relatively rare and short duration phenomenon. I therefore move that we modify paragraph J on page 18A as follows. J, shadow flicker. A utility scale WES, WEGF, or conditional use Met tower shall not be allowed to cast a shadow upon an adjacent or nearby non-participating parcel's principal structure. And then after that, he has language for a permissible amount of hours. Scratch that all. And we're going to stop with, they shall not be allowed to cast a shadow at all on a nearby non-participating parcel's principal structure. And then I've added to that, equipment and software such as Shadow Impact Module SIM by Northtech GmbH or equivalent with all necessary cabling and receptors shall be installed and maintained as necessary to stop rotation of turbines whenever a flicker event is detected. If it's only a few minutes or a little bit of time per day and only during certain times of the year, I don't see any reason with modern technology not to put the software and the receptors on it and just stop them for that little bit of time.
Kevin, a little clarity here on this. So what you're saying that these sensors and receptors would be at all non-participating peoples?
No, it will be based upon the flicker map developed and model developed by the engineers of the site. And they have made claims about how effective they are at accurately modeling and mapping this stuff out. And I would say any areas that look like they're going to be sensitive receptors to this stuff at problematic times of the year, particularly for non-participants. During the site plan review phase, seeing as this will be a special use permit, we could require this software and these receptors to be installed to stop the rotation of the turbines for what we are continually told is only a few minutes a day. If that's the case, then let's just stop it for a few minutes a day. It can't cost that much in lost production. I don't see a reason why a non-participant should endure one flicker event per second for X number of hours a day with no return to them. I don't understand why we're obligated to do that. We talk repeatedly about the rights people have to harvest their wind. I support the right of people to harvest the wind. They have that right in this township now to height up to 40 feet. I wholeheartedly support the right of people to do really stupid things on their property until it screws up the ability of the neighbor to do stupid things with their property. That's the way zoning works. So in this case, we have the technology available to reduce or eliminate one of the really obnoxious effects of utility scale wind turbines. And it's not that difficult a concept. I don't think it's that egregious of a request. And maybe it will encourage them to cite these in such a way as to really make sure they don't generate a lot of nuisance flicker effects.
Second.
It's been moved and seconded that we look at amending this section of the draft to read as was written. Is there any discussion on this?
The only thing I was questioning how other townships have handled this problem with this flicker. I was looking at one Reading Township and they didn't stop the thing turning.
How did they, what was readings
They
take
had
on?
something about not, in no event shall shadow flipper exceed 30 hours per year. And if it does, now you got a problem.
Right. I got a little note about that ordinance in Reading Township. That draft language that Dr. Lovett forwarded you was tossed by the supervisor, and he substituted his own language. And I'm trying to find my copy of the letter that explains why. I have it here. I have a copy of these things for you guys. I bring lots of copies. Well, I'll read this out loud. October 18, 2010, to Mike Cox, Attorney General, Neil Brady, Hillsdale County Prosecuting Attorney, Roger Wheeler, Reading Township Clerk, Clem Blythe, Reading Township Treasurer, Randy Wyden, Reading Township Trustee, Ron Parker, Reading Township Trustee, Hillsdale Daily News, Jackson Citizen Patriot, Lansing State Journal. The members of the Reading Township Planning Committee are submitting this letter to report that we believe Reading Township Supervisor James Galloway is carrying out actions as supervisor while in a conflict of interest. We are formally requesting an investigation of the legal status of Supervisor Galloway, who has signed a contract to lease his property to Duke Energy and is receiving financial benefits now and will continue in the future to receive additional substantial financial benefits from this contract, while representing Duke Energy's interest during the writing of the township's wind energy ordinance. On October 8, 2010, Supervisor Galloway requested the township board to reject the wind energy ordinance proposed by the Planning Commission and submitted his own ordinance dated October 8, 2010 for their approval through the auspices of Mr. Kevin Shirk, Township Attorney to the board. Mr. Shirk, however, stated in his cover letter addressed to Supervisor Galloway that the changes in the ordinance submitted to the township board were made at the direction of Supervisor Galloway and were not researched by Mr. Shirk. The changes in Supervisor Galloway's ordinance incorporate demands made by Duke Energy while removing protections to the landowners of the township. The Planning Commission reluctantly is submitting this request to investigate this conflict of interest for the following reasons. Failure to rule out the conflict of interest could result in rendering the township's wind energy ordinance null and void to make the Planning Commission and Township Board liable for costs associated with the installation of illegal turbines. 2, knowing that a conflict of interest exists or may exist, and allowing the supervisor to continue to participate in any way in the processes of developing and implementing the ordinances, licenses, or compliances makes the Planning Commission members and Township Board members complicit in the supervisor's conflict of interest. Finally, we propose a 6-month moratorium on the approval of any ordinance in order to resolve the question of Galloway's conflict of interest, and that's signed by 4 of the 5 members of the Planning Commission in Reading Township. So that draft ordinance from Reading is dead on arrival. I think it's a good ordinance. I think it covers most of these things. Very few people, including the acoustic engineer I talked to, was aware of this software in the receptors. Maybe it's a new thing, I don't know. But as I've said several times now, the developers insist that this is a very short duration event. And if that's the case, I don't see a problem with installing the equipment to eliminate it for those few minutes, those few days a year during certain climatic conditions. Like when it's overcast, it doesn't cast any shadow. I got no problem with that. I think it's reasonable.
Didn't Clinton Township, Clinton County, said you